Good afternoon. My name is Alan Crone. I'm an attorney with Crone Law Firm. We are an employment law firm here in Memphis, Tennessee. We represent employees, executives, and entrepreneurs in legal matters and disputes that might affect their ability to make money. And as always, we're coming to you to answer some frequently asked questions about a particular topic of employment law. This afternoon, we're going to talk about the Family Medical Leave Act, or more commonly known as the FMLA. Many of you may have businesses that are covered by the FMLA or be employed by an entity that is covered by the FMLA. And it's frequently misunderstood, frequently misapplied. And so we wanted to talk about some of the basic elements of it so that people know a little bit more about how to deal with FMLA leave when it comes down the pike. So the first question we have is pretty basic. What is the Family Medical Leave Act, and what are the consequences? Well, Family Medical Leave Act was passed back in the 90s, and it was primarily a method to help people adjust to important medical related occurrences in their life. One of the most prominent features is the birth of a son, maternity leave or paternity leave. And this helps people take some time off and deal with the birth or adoption of a new child. It also helps deal with other serious medical conditions, and we'll get to those medical conditions in a minute. The one thing that I want to say about FMLA leave on the front end is that it is not a separate kind of leave. It can be used in conjunction with other kinds of leaves, and basically it's 12 weeks of leave that someone can take to deal with the birth, adoption of a child or a foster child, deal with a serious medical condition of their own, deal with a serious medical condition of their parent or their spouse or their son or their daughter, or deal with an emergency situation with a member of the military. I'm going to leave that one off to the side because that's very specialized, and we may do a show just on military benefits. But basically, this isn't paid leave. It's not leave that is special in any way. What it really is protection of your job so that you can take this leave, the employee can take the leave, and the job and the benefits and seniority will be just the same as if you hadn't taken the leave. That's the main benefit of the Family Medical Leave Act. And each employee is essentially entitled to 12 weeks of that leave if their employer is qualified and it's covered in one calendar year. And you've had to have worked there 1 year before the leave is taken. And if you take the leave and come back, they can't have permanently replaced that particular employee. The company has to leave the job open for a returning employee. So what are the qualifications for the family medical leave? Well, first of all, the employer has to be a covered entity, and a private employer has to have 50 employees to qualify for the Family Medical Leave Act. So if you work for an employer that has 49 employees or 40 employees or 20 employees, and you have a serious medical condition and they say, you're going to be gone for 3 weeks? Well, we can't leave your job open for 3 weeks. We're going to terminate you. You don't have a claim under the Family Medical Leave Act. If it has 51, then you might have a claim under the Family Medical Leave Act. And there may be other claims that you might have if your employer has less than 50 employees, but the Family Medical Leave Act does not cover. You also have to be qualified for it. You also have to have worked for the employer for 12 calendar months before you take the leave, or have 1,250 hours of service for that same employer in the 12-month period immediately preceding the leave. So there are a couple of different ways to qualify. A good rule of thumb is if you've been there more than a year and they've got more than 50 employees in the company, and there are 50 employees within 75 miles of where you work, then you're covered by the Family Medical Leave Act. I know that all kind of sounds complicated. You may want to run it back and listen to it again, but that's why it's also important to, if you think you may have a claim, to go see an attorney about it, because it's not straightforward. It's very precise, and you want to make sure before you make a big deal about something that you actually are covered, and there's a legal basis to make a claim. Does my employer have to provide the FMLA leave? Yes. The company does have to provide it, provided that you're entitled to it, and there really is no ifs, ands, or buts about it. You're entitled to 12 weeks, no more. So if you can't come back to work on that first day after the 12 weeks, then you don't enjoy the protection anymore. Again, there may be some other protections you might enjoy under the Americans with Disabilities Act or some other legal basis, but not under the Family Medical Leave Act. So it's those particular claims can be very tricky because when your doctor releases you to come back to work, the timing of that can be very important. And so you want to work with a lawyer and your doctor to make sure that you're medically treated and you're taking care of your health. That's really the most important thing. But you don't want your doctor to say, well, I will give them 13 weeks when they really could give you 11 weeks or 12 weeks and comply with the statute. Do you get paid while on Family Medical Leave Act leave? Unfortunately, no, not under the law. Now, some companies will provide compensation for example, maternity or paternity leave. That's an increasing benefit that people are offering. They also have sick time or personal time or vacation time that you may be able to use in conjunction with the family medical leave. And many companies will require that. And people ask me all the time, well, I wanted to take FMLA, but my company said I had to take my sick time instead. Now, really what they're saying is you have to exhaust your sick time while you're on FMLA. Your sick time, your vacation time, your PTO time does not extend that Family Medical Leave Act leave past the 12 weeks. Some other companies have short-term disability payments, which if you're disabled, can't perform the essential functions of your job, and otherwise qualify within that, usually that product is usually an insurance product, then you can get paid while you're out on family medical leave, depending upon the cause of the medical condition that puts you on family medical leave. Now, another interesting side note to that is the medical condition doesn't have to have anything to do with your job. It's not like workers' comp where you have to be injured on the job in order to get your leave under workers' comp. Under the Family Medical Leave Act, if you have that serious health condition, and that's generally something that's certified by a doctor that will take you off of work for 3 days or more, then you are eligible for that unpaid leave. What illnesses are covered under the FMLA? Well, just about anything that will disable you for 3 or more days. As I said, it doesn't have to be work-related. It doesn't have to be, it can be any illness that incapacitates you. And it also is paternity and maternity leave when you have a birth of a child or you're getting a new child placed in your care as an adoptive son or daughter, or maybe as a foster child. Also, you're entitled to take leave if you have to take care of a spouse, a close family member, a spouse, a son or daughter, a parent. The other interesting thing is you are entitled to intermittent leave. You don't have to take all 12 weeks. You can take 3 or 4 days. You can take 3 or 4 days this week, and then maybe half a day the next week because you have to go to a doctor's appointment. I had a case when this law first came out. A man took care of his mother who had a serious health condition, and I was actually representing the employer in this case, and he used FMLA leave to take her to the doctor and to care for her when she was sick. But he also used FMLA leave to go shopping for her and to do other errands that were only collaterally connected to her illness. And so the company has to be very, very careful in making sure that each of the leave requests are properly documented. Because what ended up happening was the man actually ended up having more FMLA leave than he used, because many of the incidents were not covered under the FMLA, but were personal time or sick time that he took and qualified it under those benefit plans. And so because they weren't FMLA, he was entitled to be off, but it extended the amount of FMLA time that he had. So this is a very complicated area of the law. It requires careful accounting and careful record keeping and precision when dealing with doctors and employers and the employees to make sure that everybody is taking care of business and they're getting the leave they're entitled to, but at the same time, the companies aren't extending too much leave needlessly. Last question is, can I get fired while on FMLA leave? Well, the answer is that a company can't disturb or interfere with your FMLA leave, so they can't fire you unless you otherwise would have been fired. Frequently, I see cases where there's a reduction in force that occurs while an employee is out on FMLA leave. The accusation always is that that's in retaliation. So from a company standpoint, it's best to wait for the leave to run its course and then terminate the person if there's reason to terminate the person. But a person can't be fired because they took the FMLA leave. An area that I frequently see and that I think is difficult for companies to administer is the intermittent FMLA leave. Because people are human, and most supervisors really don't like intermittent FMLA leave. Admittedly, it's very inconvenient. It can be very frustrating when someone is out, either because they're taking care of somebody else or because they have an unpredictable need for covered leave because of their own serious health condition. And it can be disruptive to the workplace. And so frequently I find there's a lot of tension and friction between supervisors and users of intermittent FMLA leave, and that can lead to a situation where a supervisor begins to treat that person differently than they treat everybody else, and it ends up resulting in an adverse employment action, whether it's a demotion or probation or termination, and then the employee does have some recourse because when you look at the situation in total, it's clear that the supervisor has been upset, frustrated by the intermittent leave, and they lash out and they take they take adverse employment action against the employee allegedly because the person was taking the intermittent leave. And those are some of the better cases from a plaintiff standpoint that you see, particularly even with large organizations, because whereas a lot of large organizations know how to administer it in large blocks, it's just human nature that supervisors are going to be frustrated no matter how much they've been trained about FMLA leave, no matter how much they understand it on an intellectual level that they can't retaliate. It's that constant interruption, that constant frustration from having someone with a special circumstance that can be a problem. So I know we've just kind of touched the surface of the FMLA. It's a very complex It's a very complex statutory scheme, but it's a very beneficial one because it allows employees who have a temporary disability, some time to convalesce, to come back to work and be a good, productive worker. It allows people to take care of loved ones and come back and be a productive worker. It allows people to take some time with the birth or arrival of a new child to do some bonding and get into a rhythm and then come back and be a productive employee. And it's good business because one of the hardest things to do is to find a good employee sometimes, right? And so this allows some flexibility where employees can go take care of their health, take care of their family situation, and then come back and hopefully for the long haul continue to be good valued employees. So again, if you have an issue like this, I would really encourage you to, whether it's me or somebody else, contact a lawyer, go see the Department of Labor who administers and enforces this act, and inquire about your rights. Do some research online, but it's difficult because there's a book of regulations about that thick that tells you how to deal with each and every situation. Another part of the situation that's real important where you could use a lawyer to help you is dealing with your doctor and making sure that the doctor is comfortable completing the FMLA paperwork correctly. We probably could do a show just on that issue because sometimes it is a problem because sometimes doctors don't understand or are reluctant to get in the middle of the legal situation. But because of the need for them to certify the need for leave, it puts them squarely in the middle of the legal situation. So again, I hope that you've enjoyed this. My name is Alan Crone. Call us here at the Crone Law Firm at 901-737-7740. That's 901-737-7740. Or visit us online at CroneLawFirmPLC.com. That's CroneLawFirmPLC.com. Thanks and have a good day.